in-house lawyer based out of Gurugram. As an in-house lawyer, she has worked with the internal complaint committee of her organization and continuously advises the internal teams on matters relating to implementation of labor laws and organizational policies. Ms. Neha Koshi also worked with Cyril Amarchand and Mangal Das. There she advised financial institutions, private equity funds, and banks on matter of company law and financial regulations. She also advises small and medium enterprises on setting up internal complaint committees and implementation of laws for working women on pro bono basis. We welcome you, Mrs. Neha Koshi. In today's webinar, Ms. Neha is going to highlight various provisions of a maternity benefit under the Code on Social Security, equal remuneration under the Code on Wages, and then law on occupational safety for women. Thank you. Over to Devmita.
Thank you, ma'am. Before we start with today's keynote address, I'll invite VC Sir to kindly give the opening remarks for today's webinar. Sir, please. Sir, can you?
Good evening to all of you. Professor Balvinder Kaur, today's discussion for the program. Ms. Neha, advocate and author, who's going to deliver the special lecture today under XRCA platform. Ms. Devmita was anchoring and coordinating this program, along with Dr. Ankit, who are part of the digital initiative at HNLU. Dr. Deepak Srivastava, in charge registrar, present today, and other audience, which includes faculty of HNLU, students of HNLU, maybe NUJS, other law schools, would have been interested in this topic and logged in today. So let me, without wasting much time from my end on the opening remark, try to put across a few things to you of the importance of today's topic in a pandemic situation which is threatening everyone. But still, as I said, as we try to grapple pandemic and come to regular life is not a regular life in one sense, if you really look at certain perspectives of what is happening. As they say that if you say humanity, we are talking about a 50-50 kind of, I wouldn't say division, 50% of, two sets of people. One is men, 50%, average, I'm telling, 50% of women constitute what you call humanity, which we often very generally refer. But often we all know that, am I audible? Am I audible?
Yes, sir.
Yes, sir.
Yeah, because my net is down here. I'm working on my phone and connecting it. That is why there could be some mild disruptions. So anyway, my time is only about 5 minutes. I've finished 1 minute already. So what I was trying to put across to you is it, am I audible?
Yeah. Yes, sir.
Because I don't see other pictures. Am I audible?
Yes, sir, you
Yes,
are
sir.
audible.
Yes, sir.
Maybe because of the bandwidth, the images are not loading. Otherwise,
Sure.
you are audible.
Yes, sir.
Let me ask Dr. Ankit, who is audible to me. Am I audible?
Sir, you are audible to us, sir.
Okay, I will go ahead with that. So as I was discussing with you, very interestingly, we take a very generic view about humanity, but when it comes to 50% of them are men, 50% women, in a rough estimate, which I'm telling, is that life same for both, even with before pandemic or after pandemic? If you really look at it, a lot is being desired. On this topic today about workplace laws relating to women, I browsed through one of the report in recent times, about a couple of years back. It was done by Observer Research Foundation from Delhi by Terry Chapman and Vidisha Mishra in a report called Rewriting the Rules Women and Work in India. In that, if I take some highlights, it is quite alarming. It says the country's female labor force participation rate, which is often an acronym called FLFPR, stands at 27% compared to 96% of men. The pervasiveness, according to them, of these entrenched patriarchal social norms is what hinders women's agency, mobility, and freedom to work. Secondly, they point out rising household incomes that create a disincentive for labor market participation among women mainly informed by the same norms. Thirdly, they say a disproportionate burden of unpaid work and unpaid care work of women. And finally, they say the lack of quality jobs for women reinforced by gendered occupational segregations and a significant gender wage gap. This, according to this report, they are highlighting these four. There could be others. With the International Monetary Fund in globally, which often looks only at economic perspective, quite often gives additional input that India's GDP will increase by 27% if women participated in the economy at the same rate as men. So you really look at some more data which was revealed by this report. An average 66% of the work done by Indian women is unpaid compared to 12% of men. This is a global pattern, as women in other parts of the world are disproportionately burdened with unpaid work and care work. In India, according to OECD reports, women spend an average of 352 minutes a day in unpaid work against 52 minutes among men. With regard to unpaid care work, women in India spend an average 297 minutes a day on tasks such as taking care of children, the elderly, and the sick. In comparison, men spend 31 minutes a day. More than half, that is 51% of India's workforce, is self-employed compared to the 33.5% who are casual laborers, and just 15.6% are regular or salaried workers, which means vast majority of the workers put together, men and women, are not covered by the nation's labor regulation. A significantly higher number of women in India work in the informal economy compared to the formal sector. For instance, in the largely unregulated domestic work sector, there are 2.3 million women workers out of 3.9 million domestic workers in India. What does the statistics mean? One side on economics, on the other side the laws. If you look at laws, I think easily we'll have a comparative chart and tell that India has got very progressive laws. It's marching forward. But the moot point is, does equality principle, which is enshrined, does it have the desired outcome? The answer, in my opinion, will be an emphatic no. So where is the answer? In my opinion, the answer lies beyond law, in the social sphere, in the cultural compass, in the mindset, and you name it in other ways. So which all often says what we call as excellent, well-crafted laws one side, and then implementation, or how does it run actually, what it's supposed to run, is another sphere. This is some observations from my viewpoint, which makes us today's topic very important for us, that two prongs. One is the problem of awareness itself, and the second one is how does it really work on the ground. With that questions in mind, I think we have Neha Koshi, an advocate who is a luminous of NUJS and also an author of a book who has worked extensively on this, will be in a position to throw some light and her opinion on today. So on behalf of HNLU, I welcome her to XRCAR to share her views. Thank you.
Thank you so much, sir. I'd like to thank you, sir, Vivekananda, sir, Ms. Kaur, Ms. Devamita, Mr. Avasthi, and the registrars, sir, for giving me this opportunity to spend time with all of you. Like Mr. Vivekananda, sir, said, he's absolutely right. There is a huge parity in female participation in labor, and laws help in trying to push, I think the purpose of laws is to help push more women to the workplace and to aid their participation. one such law, and very important law, which tries to help women stay at work and improves their participation, is the Maternity Benefits Act. So I'm going to be talking today about provisions on maternity benefits in India, provision on equal wages, and provision on occupational safety. So let me start with maternity benefits. I'll just share my screen. So I'm going to be talking about maternity benefits. I'll give a small intro onto the history. Where does this provision come from? I'll then go and explain, how, what sort of establishments are covered under the provisions for maternity benefits. What sort of employees can get maternity benefits? Then I go on to a small, part about the calculation of maternity benefits. Then I speak about the 2017 amendments on the law of maternity benefits. So let me start off by just talking about, why is maternity benefit important? Why is maternity benefit important? I think the crucial role of maternity benefits for organizations is to help retain women employees. By providing maternity benefits to your female employees, you are giving them you're giving them a signal that your job is safe and you will be paid during the period you're taking time off for maternity leave. It's a lot more cheaper for organizations to pay maternity benefits than to let go of a female employee and hire a new female employee and spend money on training. Maternity benefits, so in that way, maternity benefits is very useful for organizations. For women particularly, it gives them an opportunity to bond with their children. It helps them ease their schedules right before they go back to work, helps them adjust with their children. It greatly helps in easing postpartum depression and anxiety amongst women. The most crucial role of maternity leave is to aid women to comply with the WHO recommendation of 6 months mandatory breastfeeding. There are numerous studies which show that organizations that provide maternity leave, in those cases, there is a greater chance that women can comply with the WHO recommendation. Now, what does that lead to? When children are breastfed for 6 months, they have greater immunity, they're a lot more stronger. In fact, their academic achievement later in life is, they have greater academic achievement later in life simply because their mothers got to spend time during their early, ages. So maternity benefit is known to greatly benefit the mothers and, more importantly, the children. What is the history of, maternity benefit law in India? The first law in India to provide for maternity leave and maternity benefit was the Bombay Maternity Benefit Act of 1929. Now, this act had its origins in the mill environment in Bombay. There were numerous mill workers and social activists. One such social activist was Dr. Florence Barnes. She had identified that numerous female mill workers who were pregnant were working 12-hour work schedules, and immediately after delivery, they were coming back to work. They were working in very unhygienic conditions. So it is because of her efforts in highlighting the situation that the Bombay Maternity Benefit Act was passed. It provided for a restriction on the work timing of women, and it also ended up giving leave for mothers to go immediately after delivery. Influenced by the Bombay Maternity Benefit Act of 1929, there were maternity benefit acts that were passed in UP, in Madras, and in West Bengal. Then centrally, the Mines Maternity Act was passed in 1921. The ESI Act was passed, and the Plantation Act was passed, all of which provided for maternity benefits. Subsequently, in 1950, the Constitution came into effect. And in the Constitution, Article 42 says the state should endeavor to provide for just and humane working conditions and maternity benefits. Subsequently, in 1961, the Maternity Benefit Act was passed. Now, let's move on to who does the Maternity Benefit Act apply to? And so the Maternity Benefit Act now has been covered under the Code of Social Security 2020. All the provisions have been covered under this new code. So who do these provisions apply to? All organizations in the public and private sectors, including contractors, have to provide maternity benefit. There is a limit for the number of employees. If you are an organization that employs 10 plus, more than 10 persons and not women, it's important to note it covers all organizations or establishments who employ more than 10 people. They have to provide maternity benefit and maternity leave to their female employees. It covers fixed workers, casual employees, trainees, and contract staff. If you're a woman, how do you avail maternity leave? You need to have been employed in that organization for 80 continuous days, and then you will be eligible to maternity benefit. How do you avail maternity leave? You need to first notify your employer that you're going to go on maternity leave. You need to provide proof of this maternity, that you're pregnant, and then after delivery you need to provide proof to your employer about the fact that you've delivered a child. The Maternity Benefit Act stipulates that women can claim a maximum of 26 weeks of paid leave. Now, this is a maximum period. If you choose to go, avail of a lesser period, you are entitled to do so. But under statute, under law, organizations are obligated to provide a maximum period of 26 weeks of paid leave. And organizations are prohibited from employing women for 6 weeks immediately after the delivery of the child. So there is a prohibition from employing women for 6 weeks after the delivery of a child, and the maximum period a woman can avail of maternity leave is 26 weeks. Now, how do you calculate maternity benefit? Maternity leave can be availed for 26 weeks. What sort of maternity benefits or payments should be paid during this period? A woman is entitled to her wages immediately preceding. The wages is calculated at an average of her wages for 3 months before she went on leave. So suppose she went on leave in December, the wages for November, October, and September are the averages calculated, and she's entitled to that. But it's important to note, she's entitled to the basic pay, dearness allowance, and retention allowance. However, this definition of wages excludes bonus payable, any contribution to the PF or EPF, any HRA, overtime allowance, any commission, gratuity, or retrenchment compensation. So the wages that she's entitled to is calculated with the average of her wages immediately 3 months before she went on maternity leave. Now let's move on to the 2017 amendment. So in the Maternity Benefit Act saw pretty significant amendments in 2017. Amongst the most prominent and the most recognized one was that it moved from 12 weeks of maternity leave to 26 weeks of maternity leave. The 2017 amendment also provided for maternity leave to mothers who are adopting children and mothers who are opting for surrogacy, to have children through surrogacy. So there was a 12 weeks leave for adoptive mothers and mothers who went through surrogacy. But it's important to note there is a slight in India, if you are an adopting mother, you are entitled to only maternity leave if you are adopting children under the age of 3 months. So you will be entitled to the 12-week maternity leave only if your child is under 3 months. If the child is above 3 months, you will not be entitled to, under statute, to this maternity leave. Also, here I want to say that the law only prescribes the base minimum. If your organization is keen to provide better benefits or more benefits, like say 30 weeks of maternity then it is entitled to do. The law only stipulates what an organization is mandatorily required to provide. Then another change that the 2017 amendment brought about was the provision of creche facilities. This creche facility can be provided by an employer directly, or he can collaborate with another organization, or he can avail of a government, run creche facility. The distance of this creche facility, how far should the creche be, would be as per the rules under the Code of Social Security 2020. The 2017 amendment also provided for work from home options for mothers. So new mothers are entitled to, work from home if their job is a sort that can be performed, it can be done at home. Now, in the time of pandemic, we all now know, whether our job is such that can be done from home or whether we have to be in our workplace. So if you have a sort of a job that can be done from home, the 2017 amendment allowed for this work from home provision. But this provision, the terms of this provision is to be decided with the consent of the employer. So only if the employer is comfortable with the work from home, the period that the employer is okay with the work from home would all depend on the agreement with the employer. Moving on to occupational safety. I think I covered what I was, what I intended to cover with maternity benefit. Regarding occupational safety, the erstwhile provisions under the Factories Act now got covered under the Occupational Safety, Health and Working Conditions Code, or we call it the OSH Code. The OSH Code is with respect to factories. It is applicable to premises where manufacturing activity is carried out with 20 or more people if there is power, or 40 or more people if there is no power. So if there is an establishment which is operational without electricity, it's 40 plus people. If it is with electricity, it's 20 plus people. So all such establishments get covered under the OSH code. Now, when the new labor codes came out with respect to women, one change that was highlighted was that the earlier restrictions on the employment of women from 7 a.m. to 5 a.m. that was done away with within the labor codes. So that change came about in the OSH code, where the earlier restrictions under the Factories Act on the timings of the women no longer apply. But employers are required to make provisions for women's safety and to help them travel from home and back. That was a change that was brought about through the OSH code. Now, like the Maternity Benefit Act, the OSH code for women specifies that factories are required to provide creche facilities where more than 50 people are employed. Then there is the earlier restrictions under the Factories Act on the employment of women in hazardous operations, like cotton open factories, or the amount of weight that a woman can lift. Those restrictions were done away with in the OSH code, and the OSH code said that the appropriate government, it can be the state government or the respective authority in that particular territory, they can now make rules and regulations regarding these restrictions applicable to women. So the earlier restrictions were done away with. An important provision under the OSH code regarding women is, which was earlier there in the Factories Act and is also now covered under the OSH code, is that employers are now responsible for providing separate toilets for men and women. This was earlier there as well in the Factories Act, but now it is now also brought in that owners of the premises are also responsible for ensuring that in the factory men and women are provided separate toilets. The OSH code also makes detailed prescriptions on how there should be separate entrance for these toilets. The toilets should be maintained by the employers. Women should be provided safety in these toilets and restrooms. So that's what the OSH code says. But So I just go over what are the most important points. The OSH code does away with the restrictions on the timing of women, that, what is the time, what is the maximum time period that women can be employed in factories. Earlier, it was a 7 p.m. to 5 a.m. restriction, which is now done away with. The creche facilities for women is stipulated under the OSH code. The OSH code does away with earlier limitations and restrictions on the employment of women in hazardous operations, the amount of weight that women can lift, the employment of women in certain occupations like cotton factories, cotton openers, that was done away with. Then also the OSH code now makes the owners of premises responsible for providing separate toilets for men and women. So this is what the OSH code provides. I mean, Devamita, should I go over the next? I'll go over the equal enumeration part.
Yeah, you can go ahead with all the parts, and then at the end we'll engage with the audience with the question and answers. And audience can post their questions, whatever relevant questions they have in the chat box. We'll take them at the end.
So about equal enumeration. Now, equal enumeration, I think it was earlier covered under the Equal Enumeration Act of 1976, I think. Now it's been brought around under the Code of Wages 2019. Now, the Equal Enumeration Act is based on a simple principle that there should be no discrimination of women and men in the wages that they are paid. It covers, under the Code of Wages, the provisions on equal enumeration cover all establishments where trade, business, or manufacturing activity is carried out. The common definition of wages, under the Code of Wages, it's the same definition of wages that applies to minimum wages and that applies to provisions like EPF and maternity benefit. Now, Equal Enumeration Act prohibits the discrimination of payment of wages when the work is the same or work is of similar nature. Now, what does that mean? If the work is the same or work is of similar nature? That means that there is no differentiation in the skill, in the effort, in the experience, responsibility, or working conditions. If at all an employer, if at all there is a difference, then the difference needs to be of a practical importance. Under the Equal Enumeration Act, it is important to know that the reduction of wages to comply is not permitted. It can only be that the wages has to be increased to comply. So if there is a man who's paid more than a woman, we can't reduce the man's salary. That is prohibited under the Equal Remuneration Act. It is that the woman's salary has to be brought in parity with the man's salary. That's what the Code of Wages provides. Now, this is just a simple synopsis. There aren't the Equal Enumeration Act. There aren't too many provisions which are covered under the Code of Wages. There are just 3-4 provisions which basically prohibit any discrimination in the wages that are provided to men and women. Now that I've covered Maternity Benefits Act, the provisions on the factories that are applicable to women, and provisions on equal remuneration, I'll just give a small snapshot about the book that we wrote. So this book was written by me and a batchmate of mine, Isha Shekhar, who couldn't make it here. We had numerous conversations between us about how there is no single book. In fact, there is no comprehensive book that covers all workplace laws for women. We have books specifically on POSH, but not too many books on maternity benefits and not too many books on Factories Act provisions for women. And in numerous, chat groups and lawyer WhatsApp groups, we kept seeing questions where people were asking questions on how is the Maternity Benefit Act implemented. So many questions on its applicability. So that's why during the last lockdown in March 2020, Isha and I decided that, let's use our time that we're at home, because this is a topic that we both are interested in. Let's write about this. And that's why we wrote this book. in this book, we've covered the POSH Act, we've covered provisions on maternity benefit, provisions on occupational safety for women, the provision on code of wages. So it's interesting, when we started out writing the book, the labor codes were not introduced. And when we were midway through editing the book, the labor codes got introduced. So we had to sit and go through the new laws and incorporate that. So we've done that. We've also gone, we've done a detailed analysis of all the precedents on workplace laws for women. So I think we've practically gone through most of the precedents on all of these 4 legislations. We had interns who went through all of them, and we have tried to cover what are the important points from these precedents, and how does the precedent expand on the law. So we've covered that as well. For organizations specifically, we've done FAQs, the most frequently asked questions on these laws. And we've done checklists. So, a checklist which says that this, if you've done all of this and you've complied with the law, if you've done all of this. So it's very useful for compliance professionals who are in this field. Also, since the law changed, we have done our detailed table where we've compared the provisions under the old law and then the new law. So, and analyze what all are the changes under the old and between the old and the new. So this is what the book was about. If there are any questions here that I haven't addressed or that I don't get to address, then you can contact me at koshi.neha@gmail.com. I'd be happy to address your questions, or if you have any queries later, you can contact me. So that's about it. That's my session.
Thank you, Neha. It's an excellent presentation. And the first question which I have received from one student, what is the maximum period of a maternity leave under the Maternity Benefit Act 1961? Am I audible?
Yes, you are.
Yeah.
So the maximum period, like I mentioned in the session, is 26 weeks. This is the maximum period under the law which you're required to provide. But if you are an organization or your employer wants to provide a greater maternity leave period, they are free to do so. But the 26 weeks is the maximum period under the law.
Right. Neha, the second question which we received from our faculty member, Demita Madam, that is whether there can be a gap in between availment of period of maternity leave, like 16 weeks joint job and then again 10 weeks, or is it to be taken at one go? Sorry.
So the maternity leave is to be taken at one go. So you have to take it continuously. But I mean, you can take it after your delivery, or you can take it, split it between or before.
Right, before childbirth and after childbirth.
After childbirth, yes.
Right. Yeah. Then another question which we got that how many times can maternity leave be availed?
So you can avail maternity leave for the delivery of 2 children. You should have had 2 children. It's not 2 times, but it is 2 children. So if you've had a miscarriage in the past, that will not be calculated, and you can take it for 2 children.
Then another question we received from our faculty member, Ankit Avasti. Can women avail work from home even after the 6 months period of breastfeeding?
These
Yes.
questions, just a minute, Neha, ma'am, these questions I am forwarding you, which I am receiving.
Okay, thank you.
very-
So
very
this
happy
is
to
a
answer.
question from the, yeah. Am I audible, Neha?
Yes, you're absolutely audible.
Shall I repeat the question?
Yes, you can. I heard it. Yes.
Can a woman avail work from home even after the 6 months period of breastfeeding?
So women can avail work from home even after the 6-month period. It all depends on whether the employer and the employee consent. So it depends on the agreement between the employer and the employee. Work from home provisions are completely at the discretion of the employer.
Right. Thank you. And then the next question which we received, that is again from the faculty member, Papa Rao sir. So, Madam, whether twins are considered as a single delivery or two deliveries, what the law says and what is the recent judgment given by Madras High Court?
So twins would be considered two children. I have to check up on this recent judgment. I think we have covered it in our book, but I think it would be considered two children. So
Yes. Then next, Neha, question is like commissioning mother. We discussed about the 2017 amendment, and there were two important things which was incorporated under the Maternity Benefit Act. That is a commissioning mother and adoptive mother. So whether these two terms or expressions, adoptive mother and commissioning mothers, are defined under the Maternity Benefit Act?
yes, they are defined.
And
Like I said, yeah.
yes, please.
Yes. So the commissioning mother and maternity adoptive mothers, they're defined under the Maternity Benefit Act. But like I mentioned, for commissioning mothers and adoptive mothers, there's a 12 weeks maternity leave provision. But it's important to note for adoptive mothers, they are only mothers of children who are under the age of 3 months. So you can only avail under the law leave this 12-week period if you have adopted a child under the age of 3 months.
Okay. Then next question is, in your opinion, should maternity protection be a state responsibility instead of employer's responsibility?
I see in a lot of countries, such as the European countries, and you have New Zealand, you have Australia. In a lot of countries, it is a state that pays the mothers, and in some cases, when fathers are adopting, they pay the parents money to manage that time when they're having children. So I would say that it is a state responsibility to pay or to provide for maternity benefit. But I understand in a country like India, where the population is so big and the resources are scarce, that it might be difficult to implement that in India. So while I think it is the state's responsibility, I understand that practically that might be difficult in India to implement.
Yes, next question which we received, that is if both husband wife are a government employee, does husband get any benefit from paternity and how much time he will get?
So it depends on the particular department. If there is a
paternity leave.
So unfortunately, this is a sad part of the law, that there is no provision for paternity leave. I think this makes it increases the responsibility on women, especially immediately after having children. And women are not able to share that responsibility because the men don't have leave.
Right.
So unfortunately, as of now, there is no provision for paternity leave in India. But many organizations are providing at this point paternity leave. It ranges from 7 days to 2 weeks to 2 months. So we are seeing reports of that. And I think that's a good trend, and the government should take note and, probably provide for paternity leave, at least 7 days to 10.
Right. So the last question will take, because the paucity of time. So the last question is, will a woman able to live up to professional standards being pregnant and bearing a child?
I mean, I think it's the organization that ends up helping women. There is no dearth of women who have done well professionally after having children. There are numerous examples around the world. You have Indra Nooyi, you have Sheryl Sandberg. So there is no dearth of examples where women have done well professionally. I think it is for the organizations to facilitate female participation in labor, and progressive maternity benefit provisions help in that.
Yes. Neha, one thing I just wanted to know, it was in 2008 that the Supreme Court permitted the commissioning, the surrogacy, commercial surrogacy in India. So what was the reason now that in 2017, that the Maternity Benefit Act incorporated this commissioning mother or surrogacy, but it was permitted by the Supreme Court in the 2008. What was the reason behind that?
So what I remember seeing was that there were numerous government circulars. In a lot of government departments, maternity leave was provided to surrogate mothers. There was even a judgment that came. I remember, I think before the amendment, there was a judgment where the court ruled that the department has to provide leave like, mothers who are delivering naturally. So it was because of the influence of those circulars and the judgment that the law got passed for surrogate mothers. So right now we have 12 weeks leave for surrogate mothers. Yeah.
Thank you. I think because of less time, we cannot take all the questions. So thank you. Yes, Dimita?
We have time on clock.
We have time. Okay. Then we will take the questions. Then there is yes, Neha. Next question is, do the laws which are specifically meant for women in the current scenario are sufficient for women, or there is still need for special legislation for women? Akram asked this question.
Okay. I think in India, especially regarding the implementation of the POSH Act, if there is something I have to say, that there is more legislation, more active involvement of the state, is regarding the implementation of the POSH Act. The POSH Act says that every district is supposed to have a local complaints committee, and this is to be provided at the state level as well. But in India, I think out of 720 districts, only 20 or 30 have even implemented it. So making that mandatory, the enforcement of the local complaints committee, as in, a body where women can go and appeal to, that is where there is a need for more laws, to enforce the provisions of the POSH Act. I think definitely there is the requirement of more laws in this area. This is one thing I can think of right now.
Right. So next question is, if employer is ready, let go women employee, but not ready give maternity benefit. In that case, what would be the situation?
So you're saying if employers are okay with letting go the women and not providing maternity benefit?
Yes, yes.
I mean, while I'm against this, it all depends on the perspective of the employer. I have myself seen employers who are stating this, but they have realized in the long run, it's a lot more, especially now that women can work from home and we are in a situation where there is work from home. They've realized that it is a lot more expensive for them to hire a new person, train the new person, trust the new person. And it is cheaper to pay that minimum maternity leave for 26 weeks than to do that than to hire people, especially if you have a larger number of employees. If it's more than 10, or if it ends up becoming a 100 employee organization, it's a lot more, tougher to retain talent and to retain people. And for that reason, maternity benefit or paying maternity benefit to pregnant mothers, it's more sensible than to hire someone new.
Neha, what would be your take on this question, that suppose if there is a violation of equal remuneration, that would be considered as a violation of Article 14 of the Indian Constitution?
Yes, but the only thing is that the violation of the constitutional rights, you can only, it's only against a state authority that you can, complain against. If it is a violation that is done by an object of this, like a state body or a PSU or, anything that falls within the definition of state, it's only against them that you can complain. That's why the Equal Remuneration Act applies to a greater number of organizations and establishments.
And then you have discussed about the Employee State Insurance Act 1948. Now it is the part of the code. right? Code on Social
Yes.
Security. Could you explain which provisions of Employee State Insurance Act insurance talks about the maternity benefit?
So, yes, we've covered this. The employee state insurance, also the provision, the body is supposed to provide maternity benefits. If the maternity benefits under the ESI provisions are greater than the provisions in that, a woman is getting under the Maternity Benefit Act, then she can opt for the ESI provisions. So the exact same provisions under the ESI Act for maternity benefits have now been implemented in the Code of Social Security. This is now covered there.
Right, a woman cannot avail maternity benefit under both the legislations.
Yes, she can't. She can't. Only whatever
Either
if
she has to avail under maternity benefit, or either she has to avail under it.
Yes, sir. Yes.
I can't see any other question, so I think if
There is
yes,
one question for Neha. Neha, some members of the audience are asking where they can avail your book. So if you could just
So
address that.
I will just share that there is a Amazon link. Let me just share that 1 second.
You can post the link in the chat box itself for all, then
Yeah.
everyone will be able to see.
So that's a link to my book. We are currently just running out of stocks, but within a week, the stocks will be finished. So you can go and buy the book on Amazon. It's available on discount at the moment. So I would really request Vice Chancellor Sir to please procure a copy for your library. We are coming out with a second edition in a few months. So that is also something that you could refer to.
thank you, Neha, for the excellent presentation. This webinar gave us a great insight about the labor enactments. We really appreciate the knowledge and insight you have shared. Once again, thank you for informative session. And over to Dimita, ma'am.
Ma'am, so now we have come to the end of today's session. As Neha mentioned, any member of the audience, if they have any doubts or if they want to institutionally reach out, they can contact her. So I'll propose the official vote of thanks on behalf of the university. My gratitude to Ms. Neha for her delightful talk today, highlighting various aspects of workplace rights for women in India. We look forward to read your book in person, of course. A heartfelt thanks to Honorable Vice Chancellor Sir and respected Registrar Sir for taking out time from their busy schedule and joining us today, gracing this webinar. Thank you, Dr. Valvinder Kaur Ma'am, for agreeing to be the discussion for today's event and contributing to the webinar. Special thanks to Dr. Ankit Avasthi and Mr. Jeevan Sagar, my digital teammates, for facilitating me wholeheartedly in organization of today's event. Thank you to our friends from print and media who covered it in the different social media platforms and helped us in promoting the event. And a big thanks to all the participants in the audience today who joined us through WebEx or through YouTube channel, because we saw a couple of questions there also. So everyone who participated in today's webinar, thank you so much. We hope you will join us again in the next webinar in the 8th series of XRCA or the other webinar series which we run institutionally. Thank you so much. Have a good evening, everyone.
Thank you. Thank you very much.
Yeah, thank you, Ms. Neha, for joining today. And indeed, you have proven that you can write a workplace book from home, right? Which means all is workplace for women, you know. Thank you very much for joining. And we also had today Professor Yogendra Srivastava, Director of the School of Law of Jagran Lake Institute, also joined to us today. Means I missed you when he joined in the beginning. Thank you very much from my end. Thank you.
Thank you. Thank you, sir. Thank you.
Thank you, sir.
Thank you, sir. Permission of Honorable Sir, I declare this session as closed. Thank you all for joining.
Thank you.